The Wind-Ups Minister.
Mr Evans, what a great pleasure it is to follow my honourable friend, the member for Boston and Skegness. I think it's the second time that I have done so in this bill, and it's a great pleasure. I'm going to try and emulate his courteous exchange with colleagues. I enjoyed his exchange with my honourable friend, the member for Stone, and with his near neighbour as well, because it is with such courtesy that we can still have a robust discussion about this literally vital issue. Mr Evans, it's been a wide-ranging debate, and I'm grateful to all honourable and right honourable members for their contributions. First, as the honourable member for Glasgow Central had the lead amendment, I want to start with some overarching remarks in response to her amendments first. But Mr Evans, this House has a fundamental choice. We can legislate, as the government proposes, to end the perilous journeys being made across the Channel by enabling Parliament to confirm that in light of the treaty that the Home Secretary signed on the 5th of December of last year, and in light of the updated evidence that the Republic of Rwanda is a safe third country, or we can put into statute a scheme that is riven with holes by amendments tabled by honourable and right honourable members opposite that makes the bill simply unworkable. Mr Evans, the new legally binding treaty with the government of the Republic of Rwanda does in fact respond to the concerns set out by the Supreme Court. It also reflects the strength of the government of Rwanda's protections and commitments, both to this scheme and to the rule of law. And I'm going to return to that point later on in my speech. But, Mr Evans, let there be no doubt that the government is focused and determined to stop the boats. We have made progress, but we must be enabled to finish the job. May I start by turning, please, to Clause 2. And this clause creates a conclusive presumption that the Secretary of State, immigration officers and courts and tribunals must start from the basis that Rwanda is safe. And it is right to say that it will not send someone to another country in breach of the Refugee Convention. The Supreme Court's ruling on the Rwanda policy recognised that changes could be delivered in the future which could address the conclusions they came to. And we've been working closely with Rwanda to address those issues. And when considered together, the treaty, alongside the evidence, and Mr Evans, I want to come back to the evidence and some of the points that honourable and right honourable members have picked up during the course of this debate later in my speech, but alongside that evidence of changes in Rwanda since the summer of 2022, it means that we can confidently conclude that Rwanda is a safe country. I'd be delighted to give way.
For giving way. If then Rwanda is a safe and secure place in which asylum seekers can live comfortable and productive lives, why should the prospect of being sent there be a deterrent?
The deterrent is because those are seeking to come to this country and not to the country of Rwanda. And I hope he listens to some more of the evidence that I'm about to set out. He sat through a fair amount of this debate, and I always enjoy taking interventions from him. But I'd encourage him to consider the evidence and some more, as I progress during the course of this speech. How could I refuse?
It is simply this. That, as he heard, I made reference to the Rwanda judgment and the case of ASM, whose claim was dismissed because, in a nutshell, of the sovereignty of Parliament in the context of immigration laws which were revoked under the Retained EU Law Act. That is a very perfect example of what the courts will do under paragraph 144 of the judgment. Does he accept that it is the sovereignty of Parliament which led the court to make that decision as they stated themselves?
As my honourable friend knows, he and I agree on a great deal, and I have paragraph 144 engraved on my heart, and we've had a number of exchanges about that. And it is clear that the court will not disregard an unambiguous expression of Parliament's intention as set out in paragraph 144. And I'm going to come back to my honourable friend a little bit later on during the course of my speech. But since the evidential position considered by the courts in the summer of 2022, there has been further specific information, further evidence and assurances from the government of Rwanda that explicitly addresses the challenges raised by the claimants and the UNHCR in the litigation, and also the findings of the Supreme Court following its judgment in November. And my right honourable and learned friend, the member for South Swindon, mentioned the evidence and the importance actually of looking at the evidence, and it's worth setting out some of that here, at least in outline. First of all, the headlines from the World Rankings, Mr Evans. The World Economic Forum Global Gender Gap Report ranked Rwanda 12th in the world for gender parity. Interestingly enough, it ranked the UK 15th. Secondly, Rwanda's overall score in the World Justice Project's Rule of Law score has increased consistently from 2019 to 2023, and Rwanda ranked first in its region and 41st out of 142 globally. I want to come back to that because that's an important point and there's more detail there. And the World Bank Group scored Rwanda at 16 out of a maximum score of 18. That's just some of the evidence. The government has also published a policy note. It published that on the date of the second reading, and it's been updated this month. There are country information notes on the Rwanda human rights, on the Rwandans' asylum system, on the government of Rwanda's evidence, on the UNHCR evidence, and a lot of that evidence is substantial and helpful, but we haven't cherry-picked evidence, unlike some, I hesitate to say some members have. There's also been other material that has been published as well. And it's worth considering that evidence because that is what has changed since the summer of 2022. Of course I give one.
And perhaps I'm being facetious in this, but perhaps seeing as though so many illegal migrants are fleeing France, perhaps we should now start thinking about a Safety of France Act next.
Well, my honourable friend might have been a touch facetious during the course of that, and she herself said it, but otherwise I wouldn't have dared to say it to my honourable friend. But I understand what she says. Suffice it to say, Mr Evans, we are confident in the safety of Rwanda, and the aim of this bill is to prevent domestic courts and tribunals from considering claims that relate to the general safety of Rwanda. Hence Clause 2, hence the points that my right honourable learned friend, the member for South Swindon, mentioned about the evidence, about the treaty and about the fundamentally changed situation. Turning to the honourable member for Glasgow Central and her amendments. She's right, the amendments seek to undermine the core objectives of this bill. She's been straightforward about that, she's nodding. We are agreeing yet again during the course of these exchanges. It'll do nothing for her street cred in her constituency, but we are agreeing at least on that point, because her amendments would undermine the provisions aimed at narrowing the grounds through which people can challenge their removal to Rwanda through courts or tribunals. The treaty agreed by both countries makes it crystal clear that asylum seekers sent to Rwanda are not at risk of being returned to a country where their life or freedom would be threatened, known as refoulement. And Mr Evans, Article 10(3) spells that out very clearly. We therefore do not accept, and this also relates to Amendments 35 and Amendment 37, tabled by the opposition, we do not accept that there is any risk of refoulement given that article, given those reassurance, and given the treaty. I will also remind honourable members opposite that the government of Rwanda, the African Union, the UNHCR have signed an agreement to continue the operation of the Emergency Transit Mechanism Centre in Rwanda. And by temporarily accommodating some of the most vulnerable refugee populations who have faced trauma, detentions and violence, Rwanda has showcased its willingness and its ability collaboratively to provide solutions to the refugee situations and to crises. The policy statement that was published by the government set out further evidence on this very point. And Mr Evans, it might just be worth for a moment or two dwelling on that, because in November 2021, the government of Rwanda set out the details of the emergency transit mechanism, and this agreement has attracted EU funding, and that will support the operation of the ETM until 2026. And Mr Evans, on the 9th of February, the EU announced a €22 million support package to this scheme, which the European Union ambassador described as a crucial, life-saving initiative to evacuate people facing major threats and inhumane conditions in Libya to safety in Rwanda. It is a significant example of African solidarity, of partnership with the European Union. And I continue with the quote, "We are grateful to the government of Rwanda for hosting these men, women and children until such time durable solutions can be found." Yet further evidence, Mr Evans, of the safety, not in the future, but now, but currently, the hundreds of thousands of refugees that Rwanda is welcoming and hosting and has done over the years. May I turn to my right honourable friend, the member for Gainsborough. I'm grateful to him for tabling his amendments. I listened intently as he spoke. The bill only allows the decision-maker to consider whether the Republic of Rwanda is a safe country for the person in question where the individual has presented compelling evidence relating specifically to the person's particular individual circumstances, and only where their claim does not relate to the risk of onward removal from Rwanda. Mr Evans, we all share my right honourable friend's desire, but this is already a high bar, both legally and evidentially, for making a successful individual claim, and Clause 4 sets that out. If people try to use this route without compelling evidence, they will have their claim dismissed by the Home Office and they will be removed. My right honourable friend mentioned people concocting evidence and mentioned fabricating evidence. But of course that is the exact opposite of compelling evidence. Concocted evidence cannot amount to compelling evidence. It cannot be merely a bare assertion. It cannot even simply be a tweet as he set out. May I turn to my honourable friend, the member for Delyn. I'm grateful to him for his amendments. I'm grateful to him for his exchange and engagement, and also for his constructive remarks. In relation to his Amendment 1, and he was the first out of the blocks to get an amendment in relation to his Amendment 1, I'm grateful for the way he set that out. We do assess that Rwanda is safe for those that are being relocated there, for the reasons that I have given. But the terms of the treaty that we have negotiated with Rwanda addresses the findings of our domestic courts and makes specific provision for the treatment of relocated individuals, guaranteeing their safety and their protection. And the implementation of these provisions in practice, it will be kept under review, exactly as he's been asking for. The Independent Monitoring Committee will look at it. Their role was enhanced by the treaty, and they will ensure compliance with the obligations agreed. I'd also say to him it's worth considering Article 4 of the treaty, because that means that in many scenarios, as is already the case, the government can and will adapt and respond as necessary. May I say to him about his other amendments? It is right that it cannot consider an individualised claim to the extent that it relates to whether Rwanda will or may remove or send the person in question to another state in contravention of its international obligations. That is already there, and there is only an extremely limited route for individual challenge. However, I would say to him that removing judicial oversight until after a person has been removed to Rwanda in its totality, and preventing interim relief, even if they can show, however unlikely, a real imminent and foreseeable risk, is unlikely to be compatible with convention rights. It's important to note, Mr. Evans, that just this week, in fact last night, the House passed legislation to add both India and Georgia to the list of safe countries to which we will be able to return nationals with no right to be here. It's also right pointing out that the Labour Party are so divided on that they couldn't even agree amongst themselves that India and Georgia are generally safe countries, and it's no wonder they can't formulate an immigration policy. But may I turn, in fact, to the World Justice Project's Rule of Law Index on that. I'm going to turn actually to some of the evidence, to the Rule of Law Index from 2023, which mentions Rwanda, in fact mentions 142 countries, listed from all the way from the top to the bottom, from Denmark at number 1, all the way down. It's important to note that in relation to Georgia, the House has already declared to be a safe country. They appear as number 48 on the list. India, number 79 on the list. The House has already passed legislation confirming that they are safe countries. Vietnam...
Very grateful for the Minister giving way on that point. On the point of India, Jagtar Singh Johal has been detained now for over 6 years. Is he saying that India is a safe country for every UK national?
No, I'm saying that this House has passed legislation last night that India is generally a safe country for the purposes set out in the legislation. And I'm pointing out to him, and I'm grateful to him for listening, to him and to other members who are listening, that India happens to be 79 in the global rankings. Vietnam, where we regularly return citizens to, is 87. Albania, we've mentioned Albania, I'll come back to it and mention it again, is 91. And Rwanda is 41st in that list. Comparables, marginally lower down the rankings than Poland, comparable to Romania, higher than Croatia, Greece, Bulgaria, Hungary, and all these other countries that are safe, that are strong international partners of this country. That is the evidence that has been published. That is the evidence that is before this House. And that evidence compellingly shows that Rwanda is a safe country. Could I turn now to Amendments 19, 20, 21 and 22 and Amendments 10? And may I thank again my right honourable friend, the member for Newark, for his engagement, for his remarks and for what he said. He is absolutely right. He set out the moral imperative that we need to act, that we need to limit individual claims, and I agree with him that we must focus on what works. In terms of my honourable friend, the member for Stone, as I said earlier, I agree with much of what he says. He's right about dualism. He's right about sovereignty. We may indeed debate sovereignty again tomorrow when we come to Clause 1. And indeed, there's a lovely accord between my honourable friend, the member for Stone, and my right honourable and learned friend, the member for South Swindon, on the very points of sovereignty, and doubtless we'll debate that again. Where I respectfully disagree with him is in his assessment as to whether it will work. As drafted, Mr. Evans, this legislation is clear. It is unambiguous, and as drafted, Parliament is setting out the law clearly, and it will work. May I turn to my right honourable friend, the member for Middlesbrough South, and of course I'll give way.
I merely repeat the point that parliamentary sovereignty has to be combined with clear and unambiguous words. The words notwithstanding are hallowed. They're in the Withdrawal Agreement Act 2020. That makes it absolutely clear. Otherwise, it is not clear, and the courts can rule against us, as they did conversely in relation to the Rwanda judgment, where they agreed that clear and unambiguous words are necessary and indeed essential with regard to claims under matters relating to this bill.
I'm grateful to my honourable friend for his intervention, and I agree with him. He is absolutely right in relation to clear and unambiguous language. However, Clause 2, as drafted, is clear and unambiguous. If I may say so, it's simply a different way of saying the same thing. Either you have a deeming clause that deems Rwanda to be safe, or you have a notwithstanding clause. Actually, Clause 2 has the joy of having both. It has both a deeming clause and also a notwithstanding clause as well. It is clear, it is unambiguous, and the courts will follow it. Turning to my right honourable friend, the member for Middlesbrough South and East Cleveland, I agree with him. He passionately believes that this is the right policy. I agree with him when he said that. He mentioned that it's important to tackle the root causes. He is right. He mentioned we must not allow this evil trade to persist again. I agree with him entirely on that. He asked about the courts and the tribunals, as indeed did the right honourable member, the chairman of the Select Committee, as also did my honourable friend, the member for Penistone and Stocksbridge as well. They asked about that. There was, in fact, a written ministerial statement that was laid earlier on today. I would encourage him to consider the detail of it. He's right that more judges are being recruited. It is important to say that deployment of the judiciary, of course, is a role for the independent judiciary. That is absolutely right to say. But more are being identified and trained, and I would encourage him and other honourable and right honourable members who mentioned that to look out for the Lord Chancellor's statement that was published today, that written ministerial statement. Yes, of course.
I ask the right honourable gentleman to clarify how, if the government can find as many as reported in the Times and Telegraph, 150 extra judges, if we could divert that judicial capacity to maybe prosecute some alleged rapists or murderers here in the United Kingdom. Could he clarify and exemplify what he actually means, and if those reports are actually true?
Well, I'm grateful to my honourable friend for that intervention, and she's right, and I sense, understand and share her passion for not only resolving the issues in relation to the tribunals, but the courts as well. And I know her background and her passion for ensuring that the court system and the backlog is dealt with, and she knows my position on that as well. I would encourage her to look at the detail of the written ministerial statement that the Lord Chancellor does set out, and it's right to say that this is in response to the Illegal Migration Act that my right honourable friends, the members for Newark and for Fareham, passed and took through this House. And it's right to say that it's there to ensure that there is capacity within our tribunal system. And I entirely agree with her, and there was an exchange on that during the course of the debate, that we must make sure that that is there in our court system as well. May I turn? Yes, of course.
I thank the Minister for giving way. Just before he moves off the contribution of the right honourable member for Middlesbrough South, I intervened on him to say that it was my opinion that if this bill was voted down tomorrow at third reading, because this would be an issue that the House had already dealt with, no similar bill would be able to be brought back again. And he was of the opinion that a substantially different one would be able to be brought back. The problem that he has is that if this House declines all of the amendments, which it is entirely likely to do, then presumably any future bill that's brought back would include all of those amendments, and therefore the House will have substantially dealt with all of those issues. So if this bill is voted down tomorrow, it won't be able to come back in any form.
Well, my honourable friend will appreciate my determination to get this bill through. I am the Bill Minister for this bill, and it's my determination to get this through today and tomorrow and through its further stages. May I turn to my honourable friend, the member for Wolverhampton North East, and thank her for her constructive speech and for the constructive tone that she adopted during the course of the debate. She is right. We are united in wanting to make this scheme work. I'm very grateful indeed to her for mentioning the Prime Minister's words in Italy, and they bear repetition. If we do not tackle this problem, the Prime Minister said rightly, the numbers will only grow. If that requires us to update our laws and lead an international conversation to amend the post-war frameworks around asylum, we must do that, because if we don't fix this problem now, the boats will keep coming. She was right to echo those words, and I'm pleased to have the opportunity to emphasise them, to re-emphasise them now. Of course I give way.
Thank the Minister for giving way. So it's been explained that the grounds for appeal, individual appeals, are exceptionally narrow. Therefore, why is it needed? Why 150 judges needed if the grounds for appeal are exceptionally narrow?
As I said in response to my previous intervention, they are being stood up in relation to the Illegal Migration Act that was taken through by my right honourable friends, the member for Fareham and for Newark, in anticipation of the work that will need to be done. It is sensible governance, dare I say it, but he's right to take me back to the individual claims, because that's what I want to turn to now in the few minutes that I have got left. Because the legislation provides that a court may only grant interim relief where there is a real, imminent and foreseeable risk of serious and irreversible harm. There must be credible evidence of that. There cannot be simply a bare assertion. And Clause 4, Subclause 5, actually cites the Illegal Migration Act, which my right honourable friends took through last summer. And it's worth setting out that within that, within Clause 39, it sets out extremely narrow range of circumstances whereby an individual claim will be made. And I would encourage honourable and right honourable members on both sides to look at Clause 39 of the Illegal Migration Act and just how tightly and just how high the threshold for serious and irreversible harm is. May I just briefly turn to new Clause 6 tabled by honourable members opposite. I was intrigued to hear the Shadow Minister state that the purpose of this clause is to invite further legal challenge. That seems to be, Dame Rosie, Labour's plan, to invite further legal challenge. That's the purpose of new clause being tabled. That is the exact opposite purpose that those on this side of the House have. We want this to work. Yes, of course.
Simply misrepresenting the purpose of that new Clause 6 is to put the Monitoring Committee on a statutory basis so that it can potentially be subject to our own domestic courts. I don't know whether he thinks our domestic courts should be lower down the pecking order than the courts of Rwanda.
I'm grateful to him for his intervention. When he was setting the policy out, in his opening, he said it will invite further legal challenges. Those on this side want to shut out legal challenges. Those on the side opposite want to encourage further legal challenges. Dame Rosie, the government has delivered a plan for immigration that will work. This builds upon the excellent work of my right honourable friend, the member for Witham, the champion of the Nationality and Borders Act 2022. It builds on the work of my predecessors, my right honourable friends, the members for Newark and for Fareham, who worked incredibly hard to deliver the long-awaited Illegal Migration Act, the toughest piece of immigration legislation until this piece of immigration. Just look at Albania. Dame Rosie, our successful deal with Albania started with small numbers, has now removed nearly 6,000 people with no right to be there. We know that the deterrence has worked because small boat arrivals from Albania are down by 94%. Legal challenges have not successfully stopped the flights to Albania. Flights have not been stopped. In fact, not a single case of Albanian small boat arrivals has reached a substantive hearing at the upper tribunal in the past year. Those on this side of the House are united in our determination to make sure this bill works. As drafted, it creates an ever tighter test that illegal migrants face removals to than they face removals to Albania. Our Rwanda bill is tougher, tighter, it goes further. We have a plan to stop the boats, and I invite honourable members to back it.
Alison Thulis.